The next topic will be form of payment of wages. Under Article 102 of the Labor Code, no employer shall pay the wages of an employee by means of promissory notes, vouchers, coupons, tokens, tickets, cheats, or any object other than legal tender, even when expressly requested by the employee. So what is the payment of legal tender? That's the Philippine peso. So there's only one currency that we allow here in the Philippines as legal tender, the Philippine peso. So even if the employee will request for US dollar or any foreign currency, the employer should not agree because it is prohibited by law. The payment of wages by check or money order under the second paragraph of 102 shall be allowed when such manner of payment is customary on the date of the effectivity of this code or is necessary because of special circumstances as specified in the appropriate regulations issued by the Secretary of Labor or as stipulated in the collective bargaining agreement. However, at present, we are using the ATM machine as a form of payment. So there are requirements. The following conditions must be met so that the payment through ATM machine will become valid. First, the ATM system of payment is with the written consent of the employee. Second, the employee must be given reasonable time to withdraw their wages from the bank facility, and such time spent by the employee should be considered hours of work if done during working hours. So the employee can request the employer to go out and withdraw the wage or his or her wage, and that should be considered compensable hours of work if done during working hours. Another requirement would be that the system shall allow workers to receive their wages within the period of frequency and in the amount prescribed in the Labor Code. So the period of frequency is at least twice a month and an interval of not less than 16 days. Not more than 16 days. Another one is that the bank or the ATM facility is within the radius of 1 kilometer to the place of work. In addition, the employee, upon request, or the employer, upon request of the employee, shall issue the record of payment of wages, benefits, and deduction for a particular period. Next, there shall be no additional expenses and no diminution of benefits and privileges as a result of the ATM system of payment. Finally, the employer shall assume responsibility in case of wage protection provisions of law and regulations are not complied with under the arrangement. This is based on the explanatory bulletin issued by DOLE Secretary Kisumbing dated November 25, 1996. Let's go to the place of payment. Under 104 of the Labor Code, the payment of wages shall be made at or near the place of undertaking, except as otherwise provided by such regulations, as the Secretary of Labor and Employment may prescribe under conditions to ensure greater protection of wages. So that is the general rule, exception if there is a regulation issued by Secretary of Labor. The time of payment under Article 103, the wages shall be paid at least once every 2 weeks or twice a month at intervals not exceeding 16 days. If on account of force majeure or circumstances beyond the employer's control, payment of wages on or within the time herein provided cannot be made, the employer shall pay the wages immediately after such force majeure or circumstance have ceased. No employer shall make the payment with less frequency than once a month. In case of payment of wages of employees who are engaged to perform a task which cannot be completed in 2 weeks, shall be subject to the following conditions. In the absence of CBA or arbitration award, the payment are made at intervals not exceeding 60 days in proportion to the amount of work completed, and the final settlement is made upon completion of work. Let's go to Article 105. To whom wages should be paid? The general rule is that wages shall be paid directly to the workers to whom they are due. In case of force majeure, the Secretary of Labor may allow workers to be paid to other person under written authority given by the concerned employee for that particular purpose. So that's the first exception. The second exception is when the worker dies, then the wage will go to the heirs without the necessity of intestate proceeding. So the company cannot demand for intestate proceeding. Well, the claimants, and under the next paragraph, second paragraph of subparagraph D, the claimants who are of legal age, they will execute affidavit attesting to the relationship of the deceased to the exclusion of other persons. Then the affidavit shall be presented to the employer who shall make payment through Secretary of Labor or his authorized representative. So in this case, the Secretary of Labor or the Regional Director will receive the payment to attest, at the same time to witness the regularity of the payment. So it will not go to other person not related to the deceased. The representative of the Secretary of Labor in employment shall act as referee in dividing the amount to be paid among the heirs. And the payment of wages under this article shall absolve the employer of any further liability with respect to the amount paid. There was a question in bar examination when the examinees were asked, define the freedom of disposal rule. This is under Article 112 of the Labor Code. The freedom of disposal rule provides that no employer shall limit or otherwise interfere with the freedom of the employee to dispose of his or her wages. And he shall not in any manner force, compel, or oblige his employees to purchase merchandise, commodities, or other property from any person or otherwise make use of such store or services of such person or any other person. So the employer should not interfere on how the employee will dispose of his income, nor compel the employee to purchase the merchandise or commodities from any other person. That is the freedom of disposal rule. Otherwise, you violate Article 112 of the Labor Code. Regarding wage deduction, this is very sensitive because there are so many wage deductions done by employers because the employees have so many indebtedness. Even the practice of giving ATM to lending companies is rampant. Article 113 provides the prohibition on wage deduction. So the rule is no employer in his own behalf or in behalf of any person shall make any deduction from the wages of his employees. However, subject to the following exception: when the employee was insured by the employer and the deduction is to recompense the employer for the amount paid by him as premium on the insurance. There must be consent of the employee also. Then for union dues, as provided in the CBA. So it's either recognized in the CBA, or if there is no CBA, it's authorized in writing by the individual worker concerned. Or in cases where the employer is authorized by law or regulations issued by Secretary of Labor. In relation to this, you have the Department Order number 195, series of 2018. There is the rule here regarding deduction of due obligations obtained by the employee from the employer or from a third person. So under this rule, paragraph B, section 10, rule 8, When the deduction are with written authorization of the employees for payment to the employer or any third person, and the employer agrees to do so, this is allowed. However, it is provided that the employer should not receive any pecuniary benefit directly or indirectly from the transaction. So if there is a cooperative and the employee obtained a loan from the cooperative and the employee execute a written authority given to the employer to deduct the monthly amortization of his or her loan from the cooperative, it is provided that first the requisite of written authorization is required, and then the employer should not receive any pecuniary benefit from it. Otherwise, it will be illegal deduction. Article 114 will tell you of deposit for loss or damage. Again, if you observe, all these laws that we discussed starts with prohibition. Article 114 also provides that no employer shall require his worker or make deposit from the deduction. Article 114, to reiterate, provides that no employer shall require his worker to make deposits from which deduction shall be made for the reimbursement of loss or damage to tools, materials, or equipment supplied to the employer. The only exception is when the employer is engaged in such trade, business, or occupation where the practice of making deduction or requiring of deposit is recognized, one, or is necessary, desirable as determined by Secretary of Labor. So what are these businesses? You have your restaurant where there are glasses, plates, there are breakables. So they can deduct or they can ask for deposit for loss or damage. However, this Article 114 should be interpreted and read in relation to 115. If there is already a damage or loss caused by the employee, Article 115 provides that no deduction from the deposit of an employee for the actual amount of loss or damage shall be made unless the employee has been heard thereon and his responsibility has been clearly shown. So the employer cannot just deduct from the deposit just because there is an allegation that the employee caused the damage. One case that I presented in my book is Ninya Jewelry Manufacturing of Metal Arts Incorporated and Alicia Abelias versus Madeline Simon Desilio and Lisa M. Trinidad, November 28, 2011. The Supreme Court herein disallowed the deduction made by the employer who is engaged in jewelry making. According to Supreme Court, it's not considered a practice in the business because in this case the employer asked the posting of cash bond and making deduction from wages owed, and if the employee will commit any loss or damage. According to Supreme Court, it's not valid because it's not a recognized practice in jewelry making. Article 116 provides also another prohibition. Started again with a prohibition that it shall be unlawful for any person directly or indirectly to withhold any amount from the wages of a worker or induce him to give up any part of his wages by force, stealth, intimidation, threat, or by any other means whatsoever without the worker's consent. Regarding withholding of wages, there are provisions in the labor code that are relevant. In withholding of wages, except for a debt due, it shall not be made by the employer. If you will be asked what's the difference between withholding and deduction, what is prohibited here is withholding, because when you say withholding, it means that a portion of the wage never reaches to the hands of the employee. If it is deduction, there is a portion of the wage that still reaches the hand of the employee. You also have Article 1708 of the Labor Code, or no, Civil Code, where the laborer's wages shall not be subject to execution or attachment except for debts incurred for food, shelter, clothing, and medical attendance. That's the prohibition on withholding of wages. So, if the lending company will force the employee to surrender his or her ATM card to ensure payment, so there is already violation here, because Article 116 is very clear. In this case, the lending company will withdraw everything that the employee will receive just to apply for the monthly amortization of the loan. So it is prohibited. The only way that this lending company is authorized to deduct from the employee's wages using its ATM or the ATM of the employees is that there must be written consent issued by the employee to the lending company authorizing the latter to withdraw using his or her ATM card a specific amount every payday with the obligation to return the balance. And secondly, the employer should not benefit from any of this transaction. Besides, it is prohibited that wages will be paid to another person other than the employee. So if the ATM is held in the hand or in the hands of the lending company, then wages is not paid anymore directly to the employee, but it is paid directly to the lending company. Article 117 also provides another prohibition. It shall be unlawful to make any deduction from wages of any employee for the benefit of the employer or his representative or intermediary as consideration of a promise of employment or retention of employment. So it is prohibited, the law is very clear and simple, promise of employment and to retain employment. So you are going to pay, or there will be deduction from the wage. And finally, you have Article 118. Again, it is prohibited, and it is unlawful for an employer to refuse to pay or reduce the wage and benefits, discharge, or in any manner discriminate against any employee who has filed any complaint or instituted any proceeding under this title, or has testified or is about to testify in such proceeding. These are described as retaliatory measures, so it is prohibited. So what will happen if the employer does not comply with the wage order? So under Section 10, Chapter 3 of the Implementing Rules of RA 6727, there is criminal liability if the employer will not comply with the wage order. There is a fine of not less than 25,000 pesos or not more than 100,000 pesos, or imprisonment of not less than 2 years nor more than 4 years, or both. Such fine and imprisonment at the discretion of the court. However, there's another problem, because it's not only criminal imprisonment. As you can see, the imposable penalty is not less than 2 years, not more than 4 years. In other words, the probation law should be applicable. By express provision here, the person convicted shall not be entitled to provision. So therefore, it is better for the employer to pay than go through the rigorous trial and get convicted but ineligible to avail of the probation law. So even if the penalty is only 2 years, but since it is non-compliance of wage order, the employer will spend the 2-year period in jail. In addition to that liability, and disqualification to avail of probation law. Section 12 of RA 6727, as amended by RA 8188, also provides that the employer concerned shall be ordered to pay an amount equivalent to double the unpaid benefits owing to the employees. So if you don't comply with the wage order, then you compute the total unpaid benefits owing to the employees, then there is the liability of double indemnity. However, the Supreme Court required that in the notice of or the compliance order or notice of compliance issued by the regional director, it should be provided there that if the employer will not pay the benefits owing to the employees, then the employer will be liable to double indemnity. That's a double indemnity rule. So that's based on that discussion. You have now the consequences. If the employer will not pay the minimum wage as ordered in the wage order issued by Rtwpb. Let's go to allowance. This is not part of the basic wage or salary of the employee, because this is paid on top of the wage or salary, and it's not even demandable. So the relevance of allowances would be that since it is not incorporated or not part of the wage, then it is not included in the computation of back wages. So if the employee is receiving an allowance and is transferred to another position where the allowance is not necessary anymore, then it can be discontinued because the employee has no vested right over allowances. We have the case of Miliaris et al. Versus NLRC, March 29, 1999. However, if allowance is by policy of the company is incorporated and become fixed and regularly given by the employer through a policy or even a CBA, then that allowance will form part of the salary or wage. It is beneficial to the employee, so it should be interpreted in favor of the employee. So general rule is that allowances are not part of the wages or salary, subject of course to limited exceptions. What about tips? Okay. A tip is generally given by the customer to the employee for good service rendered. So if you go to restaurants or service establishments, after the service rendered, you will give tips. As to how the tips will be distributed, it depends on the policy of the company. So if there is no policy of the company, then individual tips will go to the individual workers. If they have a policy that all tips should be centralized and distributed equally to all the employees, then you follow the procedure requirement. Tips are not part of the wages or salary, so therefore they are not included in the computation of back wages. However, you have to distinguish tips from the service charge. Service charge or service charges are collected by the employer from the customer, and these service charges will go to the employees. Under the old provision of the Article 96 of the Labor Code, these hotels, restaurants, lodging houses, nightclubs can collect, and the distribution should be based on 85% and 15%. But this has been amended already. So instead of giving 85% to employees to be distributed equally, and 15% will answer for losses, breakage, and distribution to managerial employees, under Republic Act 11360, this was signed in August 7, 2019. It amended Article 96 of the Labor Code, and it stated that all service charges collected by hotels, restaurants, and similar establishments shall be distributed completely and equally to all employees except managerial employees. So since it's provided by law, therefore companies or restaurants or employers can deduct, or can require customers to pay service charges. The next question would be, if you are going to abolish the service charge, the giving of service charge to employees, how will you do that? Under Section 5, Rule 6 of the Implementing Rules and Regulation, it provides that it will be incorporated on the wages of the employees based on the average, or determined on the average service charges for the past 12 months. So if the employee gets the average of 5,000 from the service charges in the past 12 months, then that will be incorporated as part of the wage, should the employer decide to discontinue the collection of service charges.